Good afternoon, and thank you for joining us today. I would like to welcome you to the FortneyScott briefing Supreme Court decisions in Harvard, UNC, and Groff, practical implications for employers. This webinar will be recorded. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's webinar will discuss the practical implications of those important decisions for employers, including how Harvard UNC decisions will impact employers' DEI efforts, what changes employers need to make in their religious accommodation process in light of Groff, and whether the affirmative action decisions will impact federal contractors' affirmative action obligations, and more. Today's presenters are FortneyScott attorneys David Fortney, Burt Fishman, Leslie Silverman, and Nita Beecher. I will now turn the program over to David Fortney to start our briefing.
Valerie, thank you so much, and good day, everyone. Thanks for spending the next hour with us to unpack some of the most controversial, significant Supreme Court decisions we have seen in decades. As Valerie mentioned, I'm really pleased to have Nita with us today. Nita, how are you?
I'm good. I'm excited.
I'm excited too. And Leslie Silverman. Hey, Leslie.
Hey, David. How are you today?
Very good. Thank you. And of course, Burt Fishman. Hi, Burt.
Hi, David and the rest. Pleasure to be here.
It sure is. Well, let's just jump right into it because we have a lot of material to cover. Just first a word about who we are. We are based in Washington, D.C. We're a law firm that counsels and advises and represents employers nationwide. Many of our clients happen to be federal contractors, so that puts us into the space of OFCCP, but also very broad-based expertise and experience, including the EEOC, National Labor Relations Board, and many of the federal as well as relevant state agencies. So with that said, let's turn to the agenda. Unfortunately, we only have 1 hour. We've got about 5 hours worth of material and thoughts. And I would like to say that we could answer all the questions, but we don't presuppose to have all the answers, but we're working our way through, like everyone, on how to address these. But the first thing we want to do is spend about the first half of our time unpacking those Supreme Court decisions. And of course, that's the Harvard decision and the North Carolina decision, and then Groff versus DeJoy on religious accommodation. The second part of the program, we want to spend some time really honing in on the practical implications. This has certainly been our experience in the last week or 10 days since these decisions came down. The clients are really grappling with, okay, what do we do? How do we run our DEI program? What's the impact on our federal contractor obligations? And a host of other considerations. So we're going to do our level best to try to engage on those issues and give you our thoughts and thinking. Well, let's begin with the beginning, as we say, and let's start with the Supreme Court decisions themselves. And Burt, I think maybe you could kick us off. Let's talk about the decisions addressing student admissions.
Be glad to do so. These came in an odd way to the court. The cases were brought under both the 14th Amendment and under Title VI of the Civil Rights Act, so that both the public and private universities were controlled by the decision. UNC even, the court wanted to control both by reaching out to take the UNC decision even before an appellate court had a chance to weigh in. So the court's review of both cases is rooted in the Equal Protection Clause, so that there was a single combined decision that affected essentially all higher education institutions in the United States. It's important to remember that prior to this ruling, creating a diverse student body was considered a compelling and substantial interest for a college to overcome the constitutional barriers to racial preferences, what we call in the law strict scrutiny, which is applied rigidly to racial preferences. Colleges were using a multifaceted, multi-level process in which race could be considered as one of many plus factors. But the Supreme Court had agreed with this approach and that it met the level of strict scrutiny in at least 5 prior decisions reaching back 45 years. For many people, those 5 cases set the tone for the next step after Brown versus Board. We can go to the next slide. We can talk about the cases more particularly. There was a 6-3 decision, the majority written by Chief Justice Roberts, who held that the university's admissions programs, unfortunately, in his view, overtly circumvented the constitutional requirement of equal protection. And it did so because these programs did not meet the traditional strict scrutiny standards of being narrowly tailored in support of a compelling governmental interest, and only then would you permit an exception to the constitutional prohibition for using racial preferences. That's exactly the standard that the universities thought they were meeting because of the prior precedents that existed. And they were all based on the rationales that the court had provided in those 5 decisions. The rationales for the prior rulings, this court said, were commendable, but they are, quote, and I'm quoting here, not sufficiently coherent for purposes of strict scrutiny. And just to remind everybody, those justifications, including all the traditional supports that you've heard, training future leaders for the public, enhancing appreciation and respect and empathy across racial and other lines, breaking down stereotypes. And the other thing to remember when you're thinking about these decisions in light of all the others we're talking about today, there has been no change in the law. The only change that has occurred is the composition of the court, and it is fascinating to note that the majority and the dissents present profoundly conflicting understandings of the role of race in our society and of the continuing impact of our history of racism. And that's the best summary I can give you, David.
I think that's a great summary and very useful. Let's a couple of key takeoffs from that in the next slide. So the court finds, if you think about, and everyone in our audience, of course, is deeply immersed in compliance, in DEI, federal contractor obligations. So begin in your mind now to align what the court found lacking with student admissions, and think about how your DEI programs are structured. So we're going to delve into this in the second half, but this is kind of a precursor to that. We want to weave this thread in. Not sufficiently focused and measurable results, objectives, in employing race in a negative manner. And what that means is, in the case of a student admission, if you pick one applicant because of race, you effectively deprive another applicant because of race. So the focus had been the benefit to the one individual. The court focused on those that were deprived of the opportunity. The court characterized this as a racial stereotyping, presuming that irrespective of socioeconomic or other considerations, arguing that individuals of races are not identical, that their circumstances vary widely, and that should be taken into account, and this lack of meaningful endpoints. So when we talk about that and the shortcomings reconciled with the Guarantees of Equal Protection Clause, those principles, I think, start to ring for me when I think about how employers, and we'll crosswalk off the legal standards, and how employers use that. But race isn't necessarily dead as a factor. And Leslie, I know that's something you've looked at, and so we want to make sure people have that as part of the clear takeaway on this decision.
Right, next slide, please. The decision is obviously quite sweeping, but as David said, the court didn't say that you could never use race. It did not completely take the use of race out of the higher admissions process. In fact, Chief Justice Roberts explicitly states that the court's decision should not be read to prohibit universities from considering an applicant's discussion of how race affected his or her life. So the court can consider an applicant's unique life experience, although there's a caution about that. But before I get to that, I also wanted to mention another noteworthy part of this case, which comes in a footnote. And what happened is the court explicitly exempted U.S. military academies from its holding. This is footnote 4 on page 22 for those of you who have read the decision. When I read it, I immediately texted my colleagues and said, does this say what I think it says? And they said, yes, it does. What happens is that in that footnote, the court acknowledges that the Solicitor General had asserted that race-based admission programs at U.S. military academies further a compelling interest in our nation's military. And this was done in an amicus brief. But what the court says is that since those academies weren't parties to the case and the issue was not addressed by the lower courts, we're not going to address this issue. And then it expressly carves the academies out of the holding in light of the potentially distinct interests the military academies have. And they do make quite a compelling case. Now, I don't know if that's a signal not to challenge the military academies on this issue, or if the court's going to bring it up in another case and maybe they will make this another case that allows race being used for strict scrutiny. I don't know if either of my colleagues have a thought on that.
Well,
No? Okay.
I mean, in most settings, I don't think you check your constitutional rights at the door when you deploy and are enrolled in one of the military academies. So I just find I understand the overarching concern, you know, of impact on the military and diversity, which sounds a whole lot like what our employers argue and are concerned about. That's the reason this footnote is so compelling to me, and a bit of a head scratcher.
I'm not sure I'd use the word compelling, but I find that the rationale for this footnote seems to undermine the rationale for the whole decision. All of us need more diversity, a better understanding of our brothers and sisters of different races and colors, and I just don't get it.
Well, my understanding is in the briefs that there was a whole argument about how national security is affected when you don't have a diverse military. And it's true, we can always show that in other places, but somehow military interests here may win out. It does show issues with this decision. Next slide. Now, as I said, the court said, yeah, you can use race in admissions in a certain way, but at the same time, Chief Justice Roberts also cautions universities that they cannot use essays or other evaluative tools as a run around the court's decision. So if a student or an applicant puts his race in an essay, in a narrative, they cannot be checking boxes. It goes back to that. It's the substance of what they say in the essay about how their race affected that particular applicant. That's what they want universities to be doing, looking at things on an individualized basis.
Well, and this decision had a lot of other, I thought, key points, and Nita, you have really honed in on some of these.
I think, especially for employers, there are 2 points in the decision. They're really dicta, but I think they lead to some cases that we will be seeing coming up. One, both Chief Justice Roberts in his majority opinion, as well as Justice Gorsuch, the only way I can put it, went off on the race and ethnicity standards that we are so familiar with the EEO-1. And Gorsuch in particular claims that in 1970s, when the Interagency Commission set up these various Black, the African American and all these other ones, that it shouldn't be used to determine eligibility for participation in any federal program. Well, we know that we use EEO-1s all the time, so I don't know what that's going to mean. It also obviously is used for the census. And then, of course, it's also used for us to determine what our availability should be with 11246. And we'll talk a little bit more about that. The other thing that I thought was interesting, and I'd like to hear everybody kind of comment on this, is race balancing. We know that race balancing is one of those things that's not allowed. That goes all the way back to Bakke. But Chief Justice Roberts doesn't give any additional guidance, but he does say that the universities were engaging in race balancing. And would the Supreme Court, if a 11246 type affirmative action plan came before them, would that be considered race balancing using these imprecise, as they described them, EEO1 categories? David, Burt, Leslie?
I'll take the first swing at that. Because the court was focused on aligning whether it be the population, for example, how many African Americans are in the general population versus how many enroll in the school, which is roughly the equivalent when we think about typical employment hiring, availability. And the reason we thought this was so significant is because that's one of the key metrics that we use to determine underutilization. Yet here the Chief Justice is stating without any explanation. So we just put this data point out there as conceptually he and 6 of the 9 justices are troubled by that and found that to be problematic. This is in the context of students, but it pretty directly translates, I think, to the employment setting potentially. Yep. That is why this is significant to me.
Now, one of the things I noticed that there is a continuing line through all of the decisions that there is an animus towards discussing groups as groups. Yeah. Gorsuch and Thomas and Roberts all talk about you have to treat people as individuals. Pushed to the limit, of course, that undermines the use of the kind of census and other data that the government is charged with collecting. So there's this odd sense of the Supreme Court criticizing the very data that the government is charged with gathering for a variety of purposes. David and Leslie, you can talk about this more, but down the road, if you get rid of groups and data collection on groups, you're also getting rid of disparate impact. And that is something that concerns all employers.
I have 2 thoughts on this. First of all, I think that perhaps some of what Justice Roberts was focused on was the fact that, at least with the Harvard admissions, it was so steady each year, the percentage of each category that was let into the university. And I'm not so sure that it translates exactly into employment. At the same time, there is just an obvious clash coming with the way the law is enforced and this concept that they're saying that is prohibited. Because when the agencies come and they enforce anti-discrimination laws against employers, they will look at availability and they will say, well, clearly you weren't working hard enough to hire people because they were available in the population. They even throw out your actual applicants saying, well, obviously we're doing something wrong. So clearly there's a clash coming.
I agree.
Well, speaking of clashes, let's go to the next slide and talk about the dissents. Wow, they were something else, let me just say. My favorite, though, is the newest justice, Justice Jackson, talks about race as the pink elephant in the room. And I was trying to find a pink elephant picture for this slide, but I think the important thing is Thomas and Jackson, both African Americans, have very different views of affirmative action. Thomas has been very clear that he found his affirmative action, he was early on in the process when he went to Yale, and it was a horrible experience for him, basically. He considers affirmative action government-imposed racism, and that he was personally stigmatized by affirmative action. Whereas Justice Jackson doesn't see that at all. They both agree about how we got where we are right now, but they disagree with whether or not continuing to look at racism, race or ethnicity is important. And Jackson believes that we're never going to move forward as a country if we don't look at race and its impact on African Americans in particular. What do you think, Leslie?
Well, I was just going to comment that I keep thinking about this and the people behind it. And I can't help but comment that, Justice Thomas wasn't early on in the process. He was the very first year that Yale did this in the very first class. And yes, he was not the only African American in his class. But then I've also read articles where he talked about how lonely he was in law school. He didn't feel a community. And it's just interesting that all these years later, we're still being driven in part by someone's experience in the very first year where affirmative action, was allowed. So I just wanted to point out that because I think it's interesting.
Yeah, I want to read this quote from Justice Jackson. The takeaway is that those who demand that no one think about race, a classic pink elephant paradox, refuse to see, much less solve for, the elephant in the room, the race-linked disparities that continue to impede the achievement of our great nation's full potential. Worse still, by insisting that obvious proofs be ignored, they prevent our problem-solving institutions from directly addressing the real import and impact of social racism and government-imposed racism, thereby deterring our collective progression towards becoming a country or society where race no longer matters. And I think her opinion is just, I have chills going up down my spine over that. Just quickly, just to conclude on that, Sotomayor read her dissent from the bench. Thomas also read his individual concurring opinion from the bench. So this was a very, very hotly debated and very difficult decision, I think, for all of them.
One of the things the dissents make clear that the majority, that Roberts tries to avoid, the dissents make clear that this case is not about college admissions alone. This is about the role of race in our society and how we deal with our history.
That's exactly right. And I thought that and underscore the sharpness of the opinions and the length of these opinions. These opinions are, collectively approaching 300 pages, 280 pages. That's a lot. And it would appear Justice Thomas's concurrence almost looked like he was hoping to write a majority opinion. Maybe he couldn't get enough signed on, and Sotomayor clearly authored. There's a lot of internal dynamics, but it's a pretty good sum up, a 360 sum up of all the competing arguments, the broader arguments, the legal arguments, the social arguments, the historical arguments. It's all there, and it's a pretty, when you look at the opinions collectively, it's a pretty good essay for that. And I think that's useful to in terms of what are people thinking. Let's just look briefly at the Pew Foundation slide next, which looks at some of the opinions. And again, this is by Pew Resource, so neutral, well-respected polling. And I think the slide has a lot of data on it, and you look more closely at it, but I think the top line is, in terms of, half of the US adults disapprove of selective colleges considering race and ethnicity in admissions, while a third approve. That's just about reflected in the Supreme Court split, 6-3. Not quite, but roughly. So as challenging as the court decision is for many, because I know many in the DEI community are deeply concerned and upset and feel the rug has been pulled out from under them, we as a country, this opinion may represent the views of more than within our sometimes smaller bubble of discussion that we realize or appreciate. And I think that's an important point, and the opinions bear this out. Yes, there's a lot of discussion about how surveys are conducted, how the questions asked, but I think, I suggest to you that this is a fairly neutral presentation, and I think is a reflective point as employers are thinking about, well, what does our workforce think about affirmative action and DEI? What do our customers think? What do our everyone? And I would suggest that these surveys are useful to help gauge the opinion at large in our society. We're a divided society on these issues, and the opinion reflects that. Well, Leslie, do you have a point on that?
I was just going to add, that survey was done a little bit before the decision was issued. I'm
Right.
interested to see what surveys come on after. I'm also interested to see whether or not it's done by adults, but we're adults all at different ages. I'd like to see also how people of different ages react. So we have to see, how this decision is going to land.
On many issues, I agree with you. There often are generational differences, but the standards are going to ultimately develop as a whole. We're not going to have, and so that's a dynamic
Right.
that we face. Well, let's shift gears from these very controversial affirmative action rulings involving higher ed and talk a little bit about the new standards governing religious accommodations. And Leslie, as the former EEOC vice chair, I think you're well suited to lead this discussion for us.
Well, thank you, David. So as we said, in addition to the Harvard and UNC case, on the very same day, the Supreme Court issued a decision in this case called Groff v. DeJoy. And in that case, the court considered whether to overturn a long-standing Supreme Court decision. And that decision was in Trans World Airlines, or TWA as we used to call it, versus Hardison. It was decided in 1977. And in that decision, the court established the standard for Title VII, under Title VII, for determining when a request for religious accommodation posed an undue hardship. In other words, how far should an employer go to accommodate an employee's sincerely held religious beliefs, and when that conflicts with some aspect of the employee's job, so they're asking for an accommodation. And the Hardison standard had been that an employer was not obligated to accommodate an employee's religion if the accommodation would create more than a de minimis or more than a minimal burden on the employer's operations. Now, although the EEOC and many courts through the years have interpreted the employer's obligation as much more than that de minimis standard or that language would suggest, the Hardison decision has been incredibly controversial for advocates for employees over the years and for religious organizations who've been asserting that because of the language in Hardison and because of the standard it set out, employers tend to give employees' request for religious accommodation short shrift. They dismiss them out of hand, and that the courts frequently back the employers. And through the years, the religious groups and advocates have been lobbying Congress for a change in the law and the standard. That happened when I was labor counsel back on the Hill. We had a hearing on it. And also in the courts, and they have been requesting a standard, because it's the same undue hardship language for religious accommodation to look like the standard under the Americans with Disabilities Act for the same undue hardship. So along comes Gerald Groff, and he's an evangelical Christian, and he works part-time as a mail carrier. And when the post office begins to deliver mail on Sundays, he switches to a smaller, more rural post office where they're not delivering the mail on Sundays. And when that changes and they start delivering on Sundays, he refuses to deliver the Sunday shifts. He offers to do Saturdays, holidays that aren't religious holidays. The post office tries to accommodate him, but in fact, what happens is that all of his Sunday duties fall to the few other coworkers in that post office. And it results in one mail carrier quitting, one transferring, the third filing a union grievance. And when he is disciplined for not working on Sundays, he quits and he sues the post office for failure to accommodate. The lower court ruled that the post offices had done what they could, that they met the undue hardship standard for his accommodation, and this teed up the issue and it made its way to the Supreme Court. Interestingly, the Supreme Court, in a unanimous decision, so this is very unusual in this court, they didn't end up overruling Hardison, but instead they actually reinterpreted the language in Hardison and said it didn't mean exactly what they said it meant. They basically wrote the word de minimis out of the decision, and they articulated a new undue hardship standard, holding that employers must grant a religious accommodation for an employee's religious practice unless it can show that the burden imposed by the accommodation would result in a substantially increased cost in relation to the employer's business. Now, this is a much higher standard than the current standard, but it's not as high as the ADA standard, which I really think would have been unworkable for religion. And this standard becomes effective immediately. Next slide. Because it's interpreting the current language of the statute, which means that it applies to all pending EEOC charges raising this issue, as well as all court cases, whether or not they're in progress. Now, the Supreme Court didn't determine whether the post office had actually met this heightened standard for undue hardship. It left it to the lower court to decide. And it answered some questions, but it certainly did not answer all of our questions. Some of the questions we do think it answered. Employer size really does matter. Larger employers are going to have to shell out more money in religious accommodations. They can't just point to a de minimis amount and say, well, we don't have to pay that amount to accommodate an employee. So premium pay for maybe covering a shift. They're more likely to have to do that for religious accommodation. The court definitely said that there would be no undue hardship opposed by temporary costs, voluntary, and occasional shift swapping. And it does seem to indicate there is a more affirmative obligation on employers to really work with employees to actually help find the shift swap for the employees and things like that. Some of the more difficult questions come to dealing with coworkers, and if a coworker, it impacts a coworker, does it impact the business? I think that the court said yes, it does, but how much it impacts the coworker and how it impacts the coworker matters. And there is language in the decision that suggests that we're going to run into an issue when accommodating an employee's religious speech might harass another employee, whether or not, in the past, it's been pretty clear that when it borders on harassment, usually the employer can say it's an undue hardship and they don't have to accommodate the employee's religious expression. But going forward, that's less clear because of language in the decision.
Thanks, Leslie. My only concern, and I think everything you said is 100% accurate, my only concern is that I look to the Supreme Court to give guidance to the country and to lower courts and to employers. And what we have ultimately is an ambiguous decision. And ambiguity leads to excessive self-regulation. Ambiguity leads to excessive burdens on employers and employees. And I think in this instance, we're going to have more claims for accommodation and more litigation. The court could have done a better job by giving a clearer standard.
Let me just add that one thing that I noticed in the decision is that the court was pretty complimentary of the EEOC guidance on religious accommodation, and even went so far as to say is that a lot of that guidance would still, apply and would work. And having worked on that guidance when I was on the commission, and it was a painstaking process to try to provide a balance showing of what the law really said. I mean, I was happy about that. So we'll just have to see how that changes. Obviously, there's going to be changes in that guidance, and they're not going to necessarily make all employers happy. But what employers want are some clear rules about what they can and can't do, and not the gotcha. And that's your point.
Well, and words of praise from this court for any sub-regulatory effort does not happen very often. So particularly by all nine, particularly in the unanimous decision. So we've done a nice job, I think, of laying in the foundation. We've covered what these decisions are. We've given some of the highlights. What I want to do is now consciously pivot and really begin to address some of the practical questions, because The truth is, most of our clients, they're not worried about how students are admitted. They're worried because of what the graduating classes may look like, but their direct concern and responsibilities deal with directly workplace matters, how employees are hired, promoted, a range of decisions are made. So let's start that discussion on the impact of these decisions on workplace matters that employers are dealing with. And Burt, can I call on you? You teed up the Harvard UNC decisions. Let's start the discussion on impact with you, please.
Be glad to do so. Again, just to remember, because of the status of these cases, it covers just about everybody in the tent under the 14th Amendment, under Title VI, to all government bodies, to anybody who receives federal money. And just to remember, even though the decision may directly affect practices of a small number of selective colleges, the skepticism towards the use of race by the Supreme Court, I think, will have an impact on how we view all efforts to remediate the effect of past and current discrimination outside the university context, and how we do that under the burdens of strict scrutiny and the lesser scrutiny that's applied to gender and other protected groups is really what's going to be developed in the ensuing years. The decisions do not directly address federal contractors' obligations to engage in affirmative action. It's been a problem in our society from the day affirmative action was coined as a word. It's applied overly broad. Federal contractors have affirmative action under the executive order that was not before the court. However, all employers obviously are prohibited by Title VII and by the Equal Protection Clause from using race-based employment decisions, but they can, under the executive order, in fact, they must, engage in targeted outreach to increase recruitment, to try to increase diversity. And the decisions only discussed race and ethnicity and didn't get into the other protected categories, which are not under the same level of scrutiny that strict scrutiny provides. The interesting thing about all of this is, there's this sense in the court that 25 years was enough. And it really does underscore the skepticism that the majority has about using race or ethnicity as a standard. And that's the part that I think is going to be most influential on the shape of DEI programs going forward and the resistance to DEI programs, both by employees and by legal foundations.
So against that backdrop and that skepticism, I think think about those survey results and kind of we're a divided country on these issues. So these issues now, I view the Supreme Court's decision as also almost being an accelerant to these decisions are going to start bubbling up more rapidly, and we have already seen a growing series of challenges to DEI programs. But in this kind of more supercharged environment, Nita, what do you see? What are you advising in terms of next steps for employers?
Well, I think we're going to start with Leslie first, and then I'm going to follow up with my thoughts. Next slide, please.
Yeah. Well, first of all, I mean, as we said, this decision does not change the law for employers, and we know that. I mean, in the very short term, of course, it was going to change the pools of that are coming out of these, especially the elite universities, because we are going to see a change fairly quickly. I guess 4 years from now, to be specific. But we can't ignore the reality that this court's decision puts a focus on employers' policies and practices, and especially their DEI initiatives, any kind of corporate pronouncements of goals and what they're looking to do in the future. All of those are going to make employers a target. There are well-funded groups out there, and they are looking for cases to challenge employer practices in this area. And they have already been pursuing them, and they're already filing sort of third-party kind of charges with the EEOC, which can be done in other places, or helping to fund the employee to bring cases. So as a result of that, we strongly recommend that employers take this time to review their policies, procedures, and practices to ensure that employees and applicants of all backgrounds are afforded equal opportunity. Now, that may seem obvious, but it's never hurt to take another look at your policy practice. And if your organization is pursuing a goal, such as increasing the percentage of Black executives at band X above at a certain percentage, you have to go back and ensure that that goal is based on actual disparities in your organization and their relevant availability. Ensure that your diversity initiatives are not limited or focused on specific demographic groups. You can still have ESGs and affinity groups, and they may pursue different goals and go about it in different ways, but everyone should be welcomed and included. And it's really important with your ESGs and affinity groups to make sure that you reach out and include workers who might have felt marginalized in the past because of DE&I. I know that the employers that I work with that do make this effort, it makes a difference to be included and not discounted. And there are ways to do it to marshal all your workforce. I mean, you're not going to make everybody happy with those, but you can get more people on board. Next slide, Nita.
Yeah, and I think, I think we've talked about this a great deal, but, one of the things that employers really need to do, just to follow on what Leslie was saying, is you can go in, and I've done presentations on this before, you can go in and look at your selection processes and find places where you may be having issues for people of color are not making it to the next step, those kinds of things. But that requires work on the part of the employer. It is very defensible because you want to make sure you're not discriminating and you can show that's why you're doing it. The other thing I think, and we can look at is as you're hiring, look at the experience of the people that you're looking at hiring. David loves to call this grit. Are you going to hire somebody because you've seen what they've overcome, and that is a reason to promote them? That's a reason to hire them over others. That's not a race-based reason. That's based on the quality of their character. And I think those are really good. And again, we talked a little bit, we'll see what happens with the race categories we use now, but at the very least, you want to look at the actual disparities in your workplace and where and focus on those. And you need to assess and refine those initiatives. And I think just the last thing before I open it for others to comment, training on this subject is really, really important. I know, having been in corporations, the CEO says, go do X, and everybody runs around with their hair on fire to do X without saying, wait a minute, what is it we really are trying to accomplish, and can we do it a different way? And then making sure the training follows through and says, you can't make these decisions based on race, but you can make them based on other things.
Let me ask you because I agree with those points, and I think directionally that's the right way to go. As we know, in the diversity space, many various tools have been developed. We've mentioned affinity groups or ERGs, employee resource groups. And so one of the takeaways I understand is that we would broaden those so that you could still have them, you just wouldn't limit participation based on the focus group. What about the Rooney Rule, as it's known, where you look to ensure that your slates are diverse, and in fact you will continue efforts until you achieve, it's typically racial diversity that the Rooney Rule is applied to. How do you think the Rooney Rule aligns with what we've heard from the court here?
I think I would be very nervous about using the Rooney Rule to make sure that you're interviewing people based on fill in the blank, race in particular. I think race is really the big concern. That's the one where you're most likely to get pushback. So I mean, that's my thought. Leslie and Burt, what do you think?
I think that this is the line that connects the affirmative action decisions and DeGroff, because it raises the fundamental question of what is the appropriate role of diversity efforts, be it in college, be it in employment, be it in government. It's the same question. And ambiguity leads to burdens, ambiguity leads to litigation, and I think that's going to be our future for many years.
I mean, I think it may depend on how the employer goes about it and does it, but there are also other things that employers do that, and experts will tell you about. Reminding managers before they go into an interview, just to things to consider that, we have this tendency to want to relate, want to hire people that look like us, that, have life experiences like that us. And when you're reminded of that, right before, sometimes that's helpful. There's also some studies that show that when you're writing a review or an evaluation, and of course those come up with promotions, that you tend to provide more feedback on someone that looks like you than somebody else. So things like that. I mean, can employers still do things like that? I would hope so, because there are biases built into us, and if we're not made aware of them, we can't try to regulate them. So I think that's important.
Good discussion. One other point I just would remind people of, in addition to 11246, Title VII does authorize affirmative action. However, it's in fairly narrowly prescribed circumstances, and it is designed as a very narrowly tailored program, quite specific to remediate prior discrimination. This is why very few employers voluntarily want to cite that they are working under the Title VII affirmative action standard, because the predicate is effectively that, yes, we've engaged in systemic discrimination, so we have to do this to cure what we did. That's not a good look, but it is there as it's still, so that component. So affirmative action, is this very broad term, but when we start to slice and dice it, there are different settings in which still affirmative action remains the law of the land. There, and I think still, at least today, under EO 11246, not discrimination, but affirmative action. All right, well, let's switch to talk about the impact of employers on Groff. Leslie, maybe I can ask you to start with that, please.
Sure. First of all, as I mentioned, EEOC is going to have to issue new guidance. I think that, while we have been talking about this, that just got a little bit easier for EEOC, because I see an alert that's saying that the 5th commissioner has just been confirmed. So there is now a Democratic majority on the commission, which, the president gets to pick the 3rd person on the commission, so they have a majority. And a lot of things have been held up at the commission at the 2-2. So we are going to see some guidance, but that does take time to write and perfect decision. Beyond that, since this new standard does come, is immediately effective, it's important that employers take action now on this. And that, first of all, it's going to require a greater individualized assessment. Really looking at each employee's request and spending time with it. Reminding managers that just because you handled the same type of request this way last year does not mean you can do it this year. You have to relook at it. And if what the employee is asking for, an employer can't do, to come up with other ways to possibly accommodate the employee. But I think the decision, and just generally from how the law has been looked at before, you can't halfway accommodate an employee. You can't say to somebody who observes the Sabbath that they can attend church every other Sunday. That's probably not going to make anyone happy. So just bear that in mind. I think that employers can do more with the documentation, both the documentation that an employee fills out so that you really understand what they're asking for, and and a little bit about why, at least, and maybe some alternatives, but also how your company or organization is going to evaluate it, and some, different aspects of it, even if it's checked boxes. But if that documentation is going to help an employer down the road, and because they have a record, and it's also going to get the decision makers to really think about the accommodation and whether or not they can make that change. To the extent you have put a standard for religious accommodation in your handbooks, you got to change those. So it may take a little review of the handbook. Usually I haven't seen that, but sometimes it does appear. Again, making sure your managers and HR folks are aware of the change. Not all of them are, staring at what the Supreme Court does, and this is a big change in its own way. So these are things that I think that employers can do on the short term to be ready. Any other thoughts?
I really think it's important to realize that if people didn't understand their right to religious accommodation, they do now, because the vaccine, as you all out there are fully aware, they understand religious accommodation in a way that is going to make your life miserable for a while. And I do worry that, especially after the most recent Supreme Court decision on LGBT rights, that we are going to see pushback on DE&I training because of religious rights, and maybe even, as Leslie, you pointed out, almost to the point of people saying, my religion allows me to not work with you, not treat you well, and that is going to be very complicated. David, Burt,
Nita, I really want to pick up on that point, because I can quickly see this devolving, because the religious protection, when you think about the Title VII protections, religion is the one that potentially conflicts or certainly overlaps with all the other recognized statutory protected categories, number one. Number two, now with this heightened standard to be defined, as we've discussed, what do you do when your DEI program training, people object to that? They object to assignments. I mean, in the field, I think, and we were awash with clients during the vaccine mandates, and that was a fairly simple, straightforward, with frankly more specifically grounded. Many were federal contractors with a federal contractor obligation to impose the mandate, et cetera, and even that was quite overwhelming for fairly sophisticated organizations. Now with this effective green lighting, my word, but green lighting to the population at large, if you have religious concerns, you should raise them. There's a forum, there's a vehicle. You don't have to do certain things if you find it is, in conflict with your religious views. And Leslie can tell us what those religious views are, but that's a very wide net, very broad, and covers things. It's not just, to remind people, not just the traditional concepts that some of us may have as lay people of what is religion. The law is very broad. So I don't know the answer to this. Is the conundrum I see, the ultimate conundrum, the workplace day-to-day operation and conflict factor.
It's very difficult, because what is a sincerely held religious belief? And really, EEOC guidance and the courts, they stay away from looking into that, what it is. But if you go to look at the EEOC guidance, it can be a completely idiosyncratic belief. But if it's sincerely held, it's a core belief, it can be considered a religious belief, even if it's not really religion in the way that we think of religion. There's a few things that they've said are not religious beliefs, but there's not a lot of cases out there, and they're not very helpful. So if you assume that a lot of things could be sincerely held religious beliefs, and if you're not sure how to maybe get out of a work thing, you can look at the internet and find something and that, which is available.
And boy, did we see that during the vaccine mandates.
I can't say it's not a problem, and it does take away from the real issues that come up with religion, and that's unfortunate. And I don't see a good solution for that. I really don't, but I wish there were, but I don't know what it is.
Burt, did you have a thought on that?
Well, I'll just say there's now a cottage industry powered by the internet to help individuals state a claim that is viable, especially now under this new standard. And I think we're going to see a great many of them. And for smaller employers, let's remember that 90% of the people in the country work for small businesses between 15 and 500. Those companies don't have the capabilities, the time, the resources to do all these wonderful suggestions that we are proposing, and there's going to be a lot of upset in workplaces on this issue.
I agree with that, Burt, and particularly because all these suggestions require a much more nuanced, individualized approach, not so much that drop-down box that allows it to be handled more cost effectively or efficiently. Well, we're drawing towards the end. We're close on time. I want to turn to our panelists for some key takeaways. What would the classic, everyone's got that 3x5 index card. We're going old school since we're talking about 50 years worth of precedent, that 3x5 index card. What's a takeaway? What do we take from this discussion? Burt, I'll start with you.
I got my card right here.
Here you go. What do you have written on it for our audience?
Kind of what I've been hinting at all through the discussion here, that the affirmative action decision will shape our society's attitudes towards race and racial preferences and the dealing with our racial history for decades to come.
Nita.
Well, I think I'm not quite as broad as Burt. My thought more is for those companies who are very focused on DE&I, while it's not directly affected by Harvard and UNC, you need to go back and look at your programs and make sure that they're in compliance with Title VII. Because if you're not, you're going to have people challenge you, and it's not going to be pretty.
Leslie.
Well, religious liberty and religious rights are clearly on the rise. This is not the end of the road with this, as you already talked about, David, because they're paramount with the Supreme Court, and we're going to see a continuous, almost like now religion swallows employment law in some ways. So we'll have to see how things shake out, but we're not done with these issues. Let me add one other thing. What we often see in these, what we used to call reverse discrimination cases, are loose lips from managers who, say to, the employee they're close with, I'd really like to keep you, I'd really like to promote you, but I have to promote someone who's purple, whatever. And those kind of comments are always going to drive these cases. So it's really important to train managers and to talk about what types of things they should be saying and what types of things they should not be saying.
It's a great point. And final thought I would have is, I think that the HR, compliance, DEI teams that are the front lines of these issues, that up to this point, and some of your ranks have been thinned through layoffs and attrition recently. I think in light of the new legal landscape, you need to reconnect with your employment counsel. I like to say, keep your employment counsel on speed dial. Most of you have employment counsel, use them, because the next 6 to 12 months is going to be a time when I think we're going to see a growing litigious environment. So be smart, don't be a defendant. That would be my takeaway. All right, one other thing, and Barry, just next slide, I just want to highlight, we do have some materials for folks, and particularly would like to call out the podcast. We dropped a podcast on our DC Insider Employer Update podcast. Wherever you listen to podcasts, you can listen to it, better yet subscribe to it, but we do those every 2 weeks or so on cutting edge issues. This podcast does a nice job, I think, of summing up some of these
You're
points.
on cam.
Additionally, we also have Jocelyn Samuels from the EEOC and some other recent developments that would be of interest. We also have a good client alert if that's helpful for each of you in dealing with your organizations. So with that, we're right on our time, and I want to thank each and every one of you, first the panelists and our audience, for joining us today.
Thank you, folks.
Thank you.
Thank you much.
We would like to thank you for joining us. You will receive a survey requesting feedback for today's presentation. You will be able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey, and of course, if you have further questions, please email us at info@FortneyScott.com. And also, as David mentioned, please listen and subscribe to FortneyScott's DC Insider Employer Update podcast, which you can find on FortneyScott.com or anywhere you listen to podcasts.